Raphael Hogarth joins us. He's an associate at the Institute of Government. He's been following all of today's events and he's at Westminster. Raphael, thanks very much for joining us. When we look at the arguments today and what they centred around, what for you stood out?
I think probably what stood out today is the sort of idea of the competing ideas of parliamentary sovereignty that we see on the one side from the challengers and on the other from the government. You know, the government is saying in this case what parliamentary sovereignty means is that Parliament can enact any law that it likes and nobody can set aside any law that Parliament enacts. And the government says, well, the Prime Minister exercised his prerogative power to advise the Queen here, and he didn't violate any statute, any Act of Parliament by doing that. What Lord Panic QC for Gina Miller, one of the challengers, was setting out this morning was a much broader, richer view of what parliamentary sovereignty actually means in the UK Constitution. The idea that for Parliament to be sovereign doesn't just mean that Parliament can make any law. It means that Parliament has to have the opportunity to make laws, and it also means Parliament scrutinising the government through questions, motions, debates and so on. So in a sense, you know, what the court is being asked to rule on this week is really the core of the UK Constitution, the sort of first rule, this idea of parliamentary sovereignty.
So that's the broad picture. To what extent did they focus on more detail in the sense of, you know, a prorogation lasting 5 weeks, which is unusual, and indeed the case being made by some people that a prorogation for, you know, overtly political purposes is something that people have done in the past?
Yeah, so there was some disagreement about this. There was some disagreement about the relevance of the time period, whether what's really under challenge here is how long the prorogation is, or the purpose of the prorogation. Some not illegal argument about that. And what Lord Panic said in his submissions, that's for Gina Miller, one of the challengers again, is what the length of the prorogation does is it gives you evidence of the Prime Minister's purpose in proroguing Parliament. He said the Prime Minister wouldn't have needed to prorogue for all of that time if the purpose were what the Prime Minister says it was, which was to sort of usher in a new domestic legislative agenda. He said no recent precedents of prorogations of this sort of length. Later in the day, Lord Keane for the government sort of pointed a little bit further back in history to the first half of the 20th century and said, actually, although we've been used to Parliament only being prorogued for a couple of days very recently, longer prorogations and prorogations in some way to get a political advantage for the government are not unheard of in the UK and not necessarily unconstitutional at all.
So as we look ahead to the next few days, Raphael, what do you think will be the upshot of 3 days of these hearings, ending on Thursday probably, we think, with Sir John Major, principally his solicitors making the case as well. Will we end up at the end of the week, do you think, with a ruling, or will we have to wait till next week?
I think it really depends on how much disagreement there is between the judges. If they all get behind the bench and say we're all of one mind, the answer is clear, then it's conceivable we could end up with a sort of yes or no ruling this week with detailed reasons to follow later. But I think if there's a little bit of debate, a little bit of uncertainty, then we're probably looking at a decision next week. Obviously, the court is going to be under a lot of pressure to make a decision quickly because they're making a decision against a ticking clock. The closer they get to the 14th of October, when Parliament's going to come back anyway, the more academic the result of the case.
Raphael, good to talk to you once again. Thanks for your time today.